Greetings and welcome to Orders and Rules from American Jurisprudence. Before we get started, just to remind everyone, this is strictly for the entertainment and educational purposes of this YouTube channel broadcast, not to be used misconstrued or
Shaggy 1776 says, hit the like button, people.
Indeed.
Shaggy 1776 says, hit the like button, people.
Oh, we got the repeat going. Let me fix that. All right, that should fix that. And as we said, nothing in this broadcast should be used, misconstrued, or misused for anything legal, lawful, personal, private, business, tax, financial, or otherwise. So please don't do this at home. That said, let's get started. So we're going to be going over.
Jared says, oh no, please don't do that off stream.
No, that disclaimer is just for the beginning. Let us proceed. Okay, so starting with where we left off last time for the motions, rules, and orders, we went over the aspects and disposition for motions. Now we're going to go over orders and rules, which are the end result of the judgments and the process as it works out. So that said, let's get with section 42, the introduction. Order and rule defined and distinguished generally. A court's primary tool for directing litigation is the order. It's a mandatory directive that can be written or verbal. So the order is a mandatory directive that can be written or verbal. A court speaks through the language of its orders. It may direct a party to act or refrain from acting or grant, deny, specified relief. An order is the exercise of judicial power regarding a cause pending before the court and is a mandatory directive for parties to comply. So once parties appear, they have agreed to comply with the orders of the court. Generally, an order is a written direction or command from the court, filed with the clerk, and not included in a judgment. So the order is not included with a judgment, but it is filed with the clerk. Generally, again, so this is generally means it's a presumption and it can be defeated. There are exceptions. An order is also a determination on a subsidiary or collateral matter that does not dispose of the case on the merits, but directs a step in the proceedings. So it's also, an order can also be just a determination on a collateral matter or subsidiary matter. And it doesn't necessarily dispose of the case on the merits, but directs a step in the proceedings. So the term can also indicate any verbal command, direction, or order made during a trial. So the practice tip here. Until the paper has been delivered by the judge to the clerk of the court to be filed by him as an order in the case, it is subject to the control of the judge and may be withdrawn at any time before such delivery. So this is an important tip here, that until the paper has been delivered by the judge to the clerk of the court to be filed as an order in the case, it is subject to the control of the judge and may be withdrawn even before that delivery. So that's a pretty tricky one there too. This must only apply to written orders here because, of course, if it's verbal, it's not directly delivered to the clerk. It's supposed to be complied with by all the parties that have agreed with those terms. Let's proceed and see how this hashes out. So, continuing with our introduction here. Although often used interchangeably, rules, orders, and rulings have distinct legal meanings and functions. The law distinguishes a rule from an order. An order is every direction of a court or judge made or entered in writing and not included in a judgment. So the order is not included in a judgment, and it's every direction of a court or judge made or entered in writing. A rule is a specific direction or requirement of the court with respect to performance of some act incidental to a proceeding. Decisions made during trial are often deemed trial rulings, not orders, regardless of whether they are written. So even if they're written, it would still be deemed a trial ruling. So it's decisions made during trials considered rulings, not orders, even if they're written. A ruling is an order made at a party's request, commanding an officer of the opposite party to do an act or show cause why it should be done. So a ruling is an order made at a party's request, commanding an officer or the opposite party to do an act or show cause why it should be done. So a burden there. Observation. Pendente liti orders, so that's during pendency or during the litigation, orders necessarily cease to exist once a final judgment in the dispute has been rendered, because their purpose is extinguished at that time, which makes sense. An order that is during the litigation, that once the litigation has reached a final judgment, then its purpose is extinguished. Let's move along here. And we're on to the critical distinction between an order and a judgment is whether the decision is final or intermediate. So this is where we get the fine distinction between an order and a judgment. Orders and judgments are distinct, though a final order is sometimes included within the scope of a judgment, sometimes. A judgment is a court's official and final determination of the party's rights and obligations. An order is any other determination by a court or judge that is intermediate in nature. The test is not the document's title, but whether it is a final adjudication of the cause or a preliminary collateral ruling. Interlocutory orders generally do not have collateral estoppel effect where no final judgment has been entered, though some may be given res judicata effect. All right, so the interlocutory orders in between the proceedings here do not have a collateral estoppel effect where no final judgment has been entered. So they will not have any estoppel effect where no final judgment has been entered, though there may be given res judicata effect, so a prior ruling here, in that interlocutory order some may be given some effect of the estoppel on a final judgment. So that's how it could affect it, but generally do not. So there are exceptions. Practice tip, though, is the practice of a trial court filing a journal entry which describes an order that is to be entered on a subsequent date has been disapproved of in some jurisdictions. So post-dating your orders, it seems like they're filing a journal entry which describes an order that is to be entered on a subsequent date. Yeah, that seems a little shady to me. Let's move along. Orders is final or non-final, interlocutory, interim, or intermediate orders. Okay, now let's split some hairs. Non-final orders manage litigation, but do not resolve the entire case, leaving further issues to be determined. A non-final order is sometimes called an intermediate, interim, or interlocutory order. An interlocutory order leaves something further to be determined or adjudicated regarding the parties and their rights. An interim or interlocutory order is made during the pendency of a cause, before final disposition on the merits. It decides some point or matter between the commencement and the end of a suit, but is not a final decision of the whole controversy. Here's an observation. In some jurisdictions, an intermediate order, unlike a final or interlocutory judgment, is not a determination of an action, but settles only ancillary matters. So intermediate order, unlike a final or interlocutory judgment. So we jumped here from interlocutory order to interlocutory judgment. So we're starting to see all these variations here. Let's proceed. And we're on to orders non-final. Final order conclusively determines the rights of the parties and ends the court's involvement in the matter. A final order determines or terminates the parties' rights regarding the issues in a suit and leaves nothing open to dispute. It represents a valid and conclusive...
Solomon 5678 says I'm just seen this pop up on my channels.
Greetings and welcome to you, and enjoy the show here. We're going over orders and rules from American jurisprudence. So what we have here is the final order conclusively determines the rights of the parties and ends the court's involvement in the matter. So, where we leave off here, it represents a valid and conclusive adjudication of the parties' substantive rights, unless overturned on appeal. An order is not final if its claims remain pending. A party's substantial rights are undetermined, or the cause is retained for further action. So, 3 things that make an order not final. If claims remain pending, a party's substantial rights are undetermined, or the cause is retained for further action. So, that's 3 aspects right there to notice if an order is final or not. The finality makes it eligible for an appeal. An order is final when no further action of the court is required to dispose of the cause, apart from ministerial matters. An order is not final if it permits a party to return to court for more damages, or leaves open the questions of additional recovery. So that makes it not a final order. So here's a practice tip. An order becomes final only when the time to appeal has expired. Interesting there. So there's a finality to it unless it's been appealed. Let's move on. Now we're on to courts use specific tests to determine finality, which has significant consequences for appeal and modification. Here we go. The test for finality is whether the trial court clearly declared its intention for the order to be its final act. The test is not the order's title, but whether it sufficiently ascertains and declares the rights of the parties. So there's no further discussion on those rights. Under the doctrine of implied severance, an order disposing of some but not all causes of action may be final if the resolved claims did not arise from the same transaction or facts as the unresolved ones. So if the unresolved issues have separate facts and they can be tried separately, so the finality of the other one would be valid. An interlocutory order may become final when the subsequent order disposes of all remaining parties and issues. So, again, the interlocutory order may become final. And I think that would become the interlocutory judgment. Or it's influencing the judgment, I think, as we read from before. Some jurisdictions permit a judge to certify an order on one claim as final, but this should be done only in exceptional cases. So here's an observation. The import of an order being final is that in some jurisdictions, such an order cannot be modified or vacated by a trial court after passage of a particular period of time. Furthermore, relief is permitted under some rules of civil procedure from a final judgment for certain reasons. So check your jurisdiction. Let's move on. And we are on to the consent or agreed orders. right, greetings to audit them. I better turn that. I didn't hear the bell go off, but there it is. It doesn't read the icons there, so I don't know if people show up or not. So now we're on section 44, the consent or agreed orders. So consent and agreed orders are binding contracts between parties that are entered as judicial decrees. So the consent orders are when parties agree and the judge basically signs off. Consent orders are in the nature of a contract and are binding and conclusive, absent fraud, mutual mistake, or collusion. Because a consent ruling is viewed as a contract, the rules of contract interpretation apply. A consent order is an agreement the parties expect to be enforceable as a judicial decree, subject to the rules applicable to other judgments. An agreed order is a recordation of an agreement between the parties. So you're recording a new agreement, not a judicial determination of their rights, and is interpreted as any other contract. A trial court has no inherent authority to force parties into an agreed order. A litigant who has consented may withdraw consent at any time before the order is signed and entered. Signed and entered. Key. An agreed order is conclusive and generally subject to appeal, except in cases of fraud, coercion, incompetence, gross disparity, or newly discovered evidence. Agreed order is conclusive and generally not subject to appeal on an agreed order. So we're talking about consent or agreed orders, which are basically contracts. We've heard of out-of-court settlements or simpler types of things. This is somewhere in between where the parties agree to particular terms and the judge basically gives a decree and subject to the rules applicable to other judgments. So we're on to ex parte order, section 45. Ex parte orders without the parties present are issued without notice to the opposing party and are typically temporary, requiring strict procedural compliance. By definition, an ex parte order is done on the application of one party and is made without notice or contestation by the adversely interested party. Under some statutes, an ex parte order is explicitly defined as a temporary order. Ethical considerations generally forbid ex parte applications in contested cases, especially on critical matters, like
King Cosmic 88 says, administrative orders.
Yes, exactly. A lot of administrative orders are ex parte orders because there is no contested case. And anyways, yeah, so administrative orders usually are done ex parte. However, in some circumstances and jurisdictions, an order may be made ex parte if the applying party complies with all applicable procedural rules and statutes. So again, rules and statutes is, we're speaking positive law here and administrative law, so to speak. So, indeed, that is very correct there. Glad to see the chat part is working well. Let's move along. Now we're on to section 46, orders and rules to show cause. Rules nisi. A show cause order compels a party to appear in court and justify why a certain action should not be taken. Wow, this is a good one, a show cause order. A show cause order requires a party to appear and present reasons why a particular order or decree should not be
Saul
taken.
Goodman 5678 says, I love show cause hearings.
Yeah, these can be quite interesting here. And then this takes us into a whole nother realm along with subpoena duces tecum and things like that. So a show cause order requires a party to appear and present reasons why a particular order or decree should not be confirmed, take effect, or be executed. A rule to show cause is not an original process to initiate a dispute. A party generally cannot proceed by rule unless the pleading is incidental to the lawsuit. So that's an interesting one right there. Rule to show cause is not an original process to initiate a dispute. where a party is already prepared in order to show cause has the same effect as a notice of motion. So where a party has already appeared. An order to show cause is made ex parte. Once issued, the notice is served on the other party, and the matter is heard, like other motions. So let's look at our practice tip here. Although generally an order to show cause may issue only after commencement of an action, where relief is sought from a court prior to the commencement of an action, in some jurisdictions, a special proceeding may be commenced by service of an order to show cause, in the same manner as a service of summons, unless the court directs an alternate mode of service. Wow. Such summary proceedings must be specifically authorized by law. So depending where you are, your rules nisi, and I think that's unless otherwise. So this is something to see here, the show cause order in different jurisdictions and those summary proceedings involving them. Those could be quite interesting indeed. Now we're on to orders and rules of show cause, rules nisi. Okay, a rule nisi is a temporary order that becomes final and absolute unless a party successfully shows cause against it. A rule nisi is a rule which will become imperative and final unless cause is shown against it. Rules nisi are the equivalent of rules to show cause and order a respondent to show cause why certain actions should not be taken. It is a process used during litigation to formally notify parties and compel their appearance at hearings for preliminary, temporary, or interlocutory matters. Rules nisi must be allowed by a court. So this is something that's mandatory, it's not discretionary. After notice and opportunity to respond, they are either discharged or made rules absolute. So the rules nisi is going to be either discharged by the response, meaning that relieved of their obligations or duties, or made rules absolute instead of rules nisi. Let's proceed here. Okay, and we're on to the show cause order here. Okay, let's see here. All right, there we go. A show cause order is a procedural tool to bring a party before the court, not a decision on the merits. So that's the show cause order, to bring a party before the court. Here's from our supplement, the cases. A show cause order is not a binding opinion on the merits in an issue before the court. It is merely the means prescribed by law and the nature of process for bringing the party into the court to answer certain demands. It does not shift the burden of proof, but is merely a method of summary procedure, like a summons. So this is an interesting one here from the Thompson versus State Board of Trustees, Public Employees Retirement System in Oklahoma, 2011. It says supplement here because we're getting this from a 2012 American jurisprudence. I'm sure there's newer cases, but these are enough here. We're really looking at the common law applications of most of these and where the statutes and rules intersect. And these cases here are relevant enough, and you can always see if there's any follow-up on them. You have the citation there. Let's proceed. So on to the judicial authority to enter and validity of orders. So we have a court's authority to issue orders depends on having both subject matter and personal jurisdiction. So the judicial authority to enter implementing orders is inherent in the equity power of the courts. A trial court's authority requires both subject matter jurisdiction and personal jurisdiction. Now, we know this. However, this is sometimes a difficult one, a hurdle to get over due to the presumptions, those standing presumptions. While orders are presumptively valid on their face, orders entered without jurisdiction over the parties and subject matter are void ab initio, a complete nullity. And this is a very difficult thing to have done, because an order is void ab initio if the court did not have jurisdiction to render it or employed an unlawful mode of procedure. An order is void if the court acted in a manner inconsistent with due process of law. Our observation here: in some jurisdictions, final orders from a motion for reconsideration are a nullity. This includes not only orders denying motions for reconsideration, but orders granting such motions as well. Now, this is interesting here.
The most beautiful Buzzkill 2331 says, "Good evening, ALL."
Yes, and good evening to you and everyone else here. So this is an interesting observation here. In some jurisdictions, the final orders from a motion for reconsideration are a nullity. This includes not only orders denying the motions, but orders granting them as well. So this would be an interesting one to look at more, because that would affect dating of appeal and the tolling of that. All right. And one other thing here I guess we would want to look at too is, let's see, where was it? Yes, on these show cause orders, that the show cause is not a binding opinion, but merely the means prescribed by law. So what this is saying, that unless they can prove otherwise, that rule to show cause will stand. So this is the powerful part about this, is that the way it says, it does not shift the burden. It's merely a method of summary procedure. But I see this as being a little a way of just semantically phrasing the same basically thing, because it is shifting a burden by having the summary procedure compel someone to show something. On the other hand, this is, like I said, when it's properly applied, it does not necessarily shift the burden in that logical sense. But I digress. Let's proceed here. The judicial authority to enter and the validity of orders. An order entered without jurisdiction is void, while an order entered with jurisdiction but containing an error is merely voidable. And as we learned before, the difference between void and voidable: void is on its face, basically, is not valid. Voidable means that there is a controversy, it's defeasible. We need to find out if it's truly void or not. But when you say it's void, that means it's not valid. Voidable means it may not be valid. An order is not necessarily void because of an error or impropriety. An order entered in error by a court with jurisdiction is merely voidable, again, because it could be corrected. Mere clerical errors do not affect the validity of orders. An order that is unconstitutional on its face is in excess of jurisdiction, though. Once a court acquires jurisdiction, its order may not be rendered void by subsequent fraud, concealment, or perjury. So look at that one. Look at this one here. Once a court acquires jurisdiction, its order may not be rendered void by subsequent fraud, concealment, or perjury. So once they have jurisdiction, they're not going to lose it because people are doing some foul play after that. After losing jurisdiction, though, a court may retain plenary power to correct clerical errors, but not judicial errors. Wow. Once they lose jurisdiction, they can fix clerical errors, but not judicial errors. Here's our practice tip. When a court is exercising a special statutory jurisdiction, there is no presumption of jurisdiction. The record must show on its face that the case is one where the court has authority to act. And if the record fails to show, the court's order or judgment is without jurisdiction and void. Special statutory jurisdiction. That's your administrative courts, it seems like. And it says there is no presumption. The record must show on its face that the case is one where the court has authority to act. And if the record fails to so show, the court's order or judgment is without jurisdiction and void. Now, that's a tough one there. I'd like to see more details on that case there, but let's proceed with the presentation. Order Section 47, the judicial authority to enter and validity of orders. Courts must be extremely cautious when declaring an order void due to the severe consequences of a collateral attack. Conditional orders are not void as interlocutory orders, but are void only insofar as they purport to be final judgments. They purport to be final judgments. In some jurisdictions, the view has been followed that, in contrast to subject matter jurisdiction, a court's lack of authority is not conclusively fatal to the validity of an order, and that consequently, an order entered without authority is voidable rather than void. Interesting there. Voidable meaning you still have to bring it into a hearing. In declaring a prior order to be void, a court must be mindful that it is setting aside a final judgment based upon a collateral attack, and because of the disastrous consequences which follow when orders and judgments are allowed to be collaterally attacked. Orders should be characterized as void only when there is no alternative is possible. This is why I say it's very difficult to get them declared void. Any order issued by a court acting without jurisdiction is a nullity from its inception. And here's our supplement case, and it's actually a rather recent one from Alabama in 2011. When a trial court purports to exercise jurisdiction where it has none, every order and judgment entered pursuant thereto is void ab initio. City of Huntsville.
King Cosmic 88 says, so it's basically amending the records with actual facts.
Let's see here. Amending the records. In these cases here, they have a judicial authority to enter. So if they're doing something where there's something that's not correct, something that was they didn't have jurisdiction to do, or some other kind of error, they can correct depending on the finality here. Let's look back here. Make sure everyone's clear on this. Oops. There. Come on. There we go. All right. So we had the this is where we started with the court's authority to issue orders depends on having both subject matter and personal jurisdiction. So let's see. This is the one. An order is void ab initio if the court did not have jurisdiction to render it or employed an unlawful mode of procedure. So that's one there. And amending it with facts. No, let's see here. Nope. Let's see. I think it would be that mindful. Yeah, this is the whole thing is that if there is an error in the way they came about the judgment, and it shows nothing, this is very general here. We're not giving any kind of specific errors. But after losing the jurisdiction, the one thing they can correct are the clerical errors, but not the judicial errors. They have full plenary power to do that, but after losing jurisdiction. Now, this is interesting how they lose jurisdiction. They can't lose it by subsequent fraud, concealment, or perjury. So an order that is unconstitutional on its face seems like the best way to show they're in excess of jurisdiction, and that way they would lose jurisdiction. However, they would have plenary power still to correct any kind of errors in the clerk's record or on the docket, so to speak. So it seems like there is a few different avenues here for making amends. I hope that cleared that up. And this is a very important case here, probably to take note of City of Huntsville versus Colsa Corp. In Alabama 2011. When a trial court purports to exercise jurisdiction where it has none, every order and judgment entered pursuant thereto is void ab initio. And we're on to the construction of orders. Clear court orders are enforced as written, but ambiguous orders must be interpreted by the court. So all court orders are presumptively valid on their face. The proper interpretation of a court order is a matter of law. Trial courts have the authority to interpret their own orders, especially when the terms are ambiguous. Where the language of an order is clear, it is generally not subject to construction. Courts must construe orders in a manner consistent with the best interests of justice and according to their substance and function, not just their titles. So again, we've learned from everything from motions, orders, titles don't have much bearing on them, the substance does. And as we see here, construction. The language of the order is clear. It's not subject to construction. It's clearly construed. The courts must construe the orders in a manner consistent with the best interest of justice and according to their substance. So the better the language of their substance is, the better the courts can construe the orders in a manner consistent with the best interests of justice and, of course, their intent. The definition here is an order is ambiguous so as to require construction, meaning that it could be misconstrued if it is subject to more than one plausible construction, or if, when read by a reasonable, prudent person, is susceptible of more than one meaning. So that's your definition of ambiguous. You can get more than one plausible construction of, or when read by a reasonably prudent person, is susceptible of more than one meaning. Here's your definition of ambiguous when it comes to orders. And on the construction of orders, the courts use established rules of contract interpretation to ascertain the meaning of ambiguous orders. So we look at it like a contract. So court orders are construed in the same manner as other written documents and contracts. If the language is clear, the literal meaning controls. If ambiguous, the court looks to the circumstances surrounding the order, including the motion that prompted it. Courts may look at the language of the order, the pleadings, and the findings. Words must be given their ordinary and customary meaning, not a strained or unnatural interpretation. Litigants are entitled to rely on the reasonable interpretation of orders. Ambiguities are construed against the prevailing party who drafted the order. Okay, key one right there. The ambiguities are construed against the prevailing party who drafted the order.
Says good one.
Indeed, that's a real good one there. And an order will not be construed as granting relief that was not demanded in the motion. Key thing here is that you always ask in any other relief the court deems necessary or correct, or whatever the language might be, allows that to be open-ended so that the court can act sua sponte to provide relief that was not demanded explicitly in the motion. All right, and that brings us on to section 48, and this is our final section, the construction of orders. A court's intent is the determining factor in interpreting its orders, including its silence on certain issues. When a state Supreme Court interprets orders, the determining factor is the intent of the issuing court regarding the issues the judgment was meant to decide.
King Cosmic 88 says, child and common child.
Not too sure what that means, but perhaps you could elaborate. So when the state Supreme Court interprets orders, the determining factor is the intent of the issuing court regarding the issues the judgment was meant to decide. So the determining factor is intent in interpreting orders. In determining intent, the court considers the trial court's entire writing. When a trial court clearly intends its order to be a final adjudication, its silence on requests for relief can be construed as a denial of those requests. Where a trial court's ruling is silent with respect to any demand at issue under pleadings, such silence constitutes an absolute rejection of that demand. So that's interesting there. The court's silent. When a trial court's ruling is silent, that's a ruling, with respect to any demand at issue under the pleadings, such silence constitutes an absolute rejection of that demand. That's called the cold shoulder. So, and our final observation. The written order generally controls over any oral order. So, if there is an oral order that conflicts with a written order, the written order generally controls. So I wonder what the exceptions are, and I guess that's something as food for thought. That brings us to the end of this presentation of orders and rules, and takes us actually to the end of this whole section of American jurisprudence, which is motions, orders, and rules. And it gives us a really good foundation of how these all fit together and the way we access the courts at all levels. So as very basic functions, as we learned, I guess most importantly, the orders are the way that the court speaks. So this is speaks to the language of these orders. And the rules are used for guidance here as far as as the trial progresses. And it's the parties' obligations and keeps everything moving ahead so that there could be a resolution of the controversy at hand and that cause of action. So with that, I hope everyone had a good time learning about the motions, rules, and orders. It's taken us to the end of this whole volume of American jurisprudence. So salute to you all for the journey, and I hope to see you all on the next one. Peace out.